All right, everyone. Hi, this is Tansen and Dominique, and we may have Randall coming to join us, but today is March 18th, 2020. Welcome. Thank you for joining us. We're having the Brilliance in Commerce Trust webinar today. Randall Hillner, as you know, is the head of our trust department, and he's been going through an interesting period in his life where he had to go to the doctor today, and uh, he's not been feeling too well. And then his computer, he had no Wi-Fi because of the weather. Something happened to his Wi-Fi. But meanwhile, he has been mentoring Dominique. And of course, had the great blessing of being taught by him for many, many years. And we're both learning. We're still learning. And you are learning with us. So we will all join and pool our knowledge today together. Randall did give us notes to follow, and he may join us. We'll see how it unfolds. So we have a background of la vérité, which means the truth in French, representing our organization. House of Freedom International Natural Law Trust is the asset protection department of Brilliance in Commerce. Those of you who already enjoy one of these trusts know how good it is. Those of you who have yet to get one may learn today more of the benefits and how it works, and perhaps give you the basis for forming one for your own use. Liberty Debt Elimination System is liberating people from the illegal false debts that the system has gotten people into. And we have a lot of other affiliations, as you may know, at BIC. We are signatories to the International Charter, the Worldwide Charter for Fair International Commerce, and look at that portion of our website. And then today is 1 month from now, well, today, March 18th, 1 month, April 15th, will be our next trust webinar. So put that on your calendar. And to play back previous webinars, go to www.brilliance-videos.com. And for those who like a telephone number, 360-200-7521. For those who have not already subscribed to the BIC newsletter, please do so at house-of-freedom-trust.com and click on newsletter sign up. My name is Tansen Fairmont. I'm the founder and consultant on Bank Instruments investment programs, former speaker at radio shows and offshore investment seminars. I authored the book Sovereignty Consciousness in 1997, and I'm still working on a new one, Cosmic Renaissance, which hopefully one of these days will finally be published. Today's topic, again, House of Freedom International Natural Law Trust. We call it natural law because it is basically a common law trust that is a little better, a little more refined, a little more perfected, a little more sophisticated, blended, synthesized, improved, and evolved than the common law trust. So we decided to call it natural law. That's actually the universal law that common law aspires to. International because it's equally applicable in all countries and is not subject to the jurisdiction of any. It is not under a statutory jurisdiction for its permission to exist or its authority to operate. It is only subject to a jurisdiction voluntarily according to transactions. If transactions need to be litigated, it could volunteer to a certain limited jurisdiction for limited purposes for only certain transactions and only the actions of certain officers on the trust board, but not the trust itself. And for that reason, we quietly refer to it as sovereign. Randall Hillner is the head of our trust department at Brilliance in Commerce, the founder of House of Freedom Trusts, White Light Unlimited, One People's Public Trust, and he's the creator of the International Natural Law Trust, which everyone you need to know does derive from at least 5 decades of study. 30 years for Randall, another couple of decades of his mentors, and then even before that, There were evolutions with the Massachusetts Trust and many of the world's wealthiest families like the Kennedys, the Rockefellers, the Mellons, the Carnegies, the Hunts, and so on. Dominique Hackett is on with us today of Santa Barbara, is past CFO of two construction companies, a C corporation and an S corporation that she helped incorporate. She's done cost accounting for construction projects as large as $34 million. She runs her own California limited liability company that includes trustee services. She has installed double entry accounting systems, and she is currently on the board of two statutory 501(c) nonprofit corporations, one of which she helped to get started. Likewise, she is co-trustee of a natural law trust from Brilliance in Commerce. She provides professional trustee services. She is a California public notary. She provides assistance to Brilliance in Commerce Trust clients, and she teaches the monthly BIC Trust Study Group series. Today's topic, all about beneficiaries and the transfer of beneficial interest. And Dominique, I would like to ask you for the date. For those who do have the Natural Law Trust, what is the date in April of the next, is it the 8th for the next trust study group?
Sure, let me look real quick. I think you are correct.
It's 1 week before this next webinar.
Let's see, first, second, I believe it is the 8th. Yes, it is.
April 8th will be the next trust study group webinar that Dominique teaches, and that is for trust clients only. So pay attention to newsletters for that and put it on your calendar. And Dominique, are you ready?
Sure, let's have some fun.
Let's have some fun.
So today we are talking about beneficiaries, and it's really fun to start with definitions. Hang on one second, there we go. Aha. And first of all, just to let everyone know, I'm no longer, once upon a time, I was a certified stockbroker and insurance agent. I no longer hold any licenses of anything. So the information we're sharing is based upon freedom of information, and the beauty of Randall's Trust is that it's based on contract law, the unalienable right that we have in, especially it's stated in the US Constitution, to contract with one another. So Randall, as the trust writer, has helped create this beautiful contract that enables us to have someone who is a grantor or a settler who wants to do something of benefit for someone else. And in doing so, the grantor contracts with someone who promises to uphold this contract for the grantor. So the grantor contracts with someone he trusts, who is the trustee. And the trustee promises to care for the beneficiary. So we are talking about the beneficiary today. And I really appreciate that Randall and Townsend called these seminars Ascending Evolution and Trust Knowledge, because we are all growing in our understanding of how to, well, number one, whether we want to get involved with a private, irrevocable trust instrument, which is what Randall has written. He's written a trust indenture, which is a contract. And if you don't have one, you're attending this seminar to see if you want to get one. And if you do have it already, we are learning more and more about trust administration. So today we're going to be focused on the beneficiaries. So the first thing that we need to understand about our beneficiaries is the fact that the beneficiary's interest in the trust, it is alienable, and then there's times where there's something that's non-alienable. So first of all, let's talk about the beneficiary is someone who has an interest in the trust, but they don't hold title. So the person who's holding the title of the trust assets, the trustees, are holding the title for the trust, and it's for the benefit of the beneficiaries. That's why we have a trust. We have a trust to accumulate assets for the benefit of our beneficiaries. And it's kind of interesting, benefice, it actually comes from with the monks and the ecclesiastical. Way back in England, you would have a monk or a nun who would be granted either a life, some sort of a life income that would go to the church, something that would help care for them as they fulfilled their religious duties. So the idea of receiving a benefit is a very old concept, and it's something that societies have worked with for a long time, of how do you have someone who has land or monies and they want to benefit a third party, but they don't want them to hold title. And why is it that we would want to benefit someone but not necessarily give them title? The reason for that is to afford them greater protection, such that by not owning the title of an asset, they can't have it taken away from them. So the idea of alienable, that means our ability to transfer something. So for the most part, as a beneficiary, we would say that usually beneficial interest is non-transferable unless there is a direct provision or stipulation in the trust that says that it is transferable. So for example, say you are a beneficiary of a trust, and later on in life, you get married and you have children. If you are the beneficiary of one of Randall's private irrevocable trusts, you could have a conversation with the trustees of your trust, and you could say to them, hey, I would like to share my beneficial interest with my children, with my offspring. And in that way, you could ask your trustee, you know, here's my my certificate, my unit of beneficial interest. How about we divvy this up so that I have some, and then some are also given to my children, so I know my children will be well taken care of. So that's a way that a beneficiary, if the trust indenture is written this way, a beneficiary could work with a trustee and be able to transfer some of their beneficial interest, but they can only do it with the blessing and of the trustee. They can't do it in and of themselves. So the unit of beneficial interest that is held by a beneficiary in Randall's trust indenture, they cannot sell that, and it cannot be encumbered. So Tanzan, would you like to go to the next slide? Each beneficiary is the equitable owner of the trust estate, and their interest is property, so that they each can have a right to sell their property. So what that's saying is that legally, the beneficiary has an interest in the property, but it doesn't have, the beneficiary doesn't have title. There is a very specific difference in the interpretation of law between interest and title. They are not synonymous. So a beneficiary has an interest in the property, and that's part of contract law and it's part of property law. But here's an example. Say that A makes a contract with B that A will pay C a certain sum of money. So B, who is our trustee, has a legal interest in the contract, our trust indenture, and C would have the beneficial interest. So in property law, interest is looked at as property, land, or some real thing. So beneficiary has interest in the trust assets. And the way that Randall has written his beautiful trust indenture, it's so beautifully written the trustees have a lot of discretionary ability of how they can best serve the interest of the beneficiaries. And in that, they're able to offer greater protection to the beneficiaries because of the way that the trust indenture is written and describes the trust powers. Could we go to the next slide? Each beneficiary can only assign his interest. He cannot sell the trust, residence, land, property, real things, the trust property itself, because the beneficiary doesn't have title. They only have interest. And that interest, it's a legal term, and it's very specific, although not defined in detail in the trust indenture. The way that the trustees are able to work on behalf of the beneficiaries is so beautiful. They're able to care for each of the beneficiaries in the way that those beneficiaries need best be cared for, based on the trust assets and based on what the grantor or the settlor wanted done with the trust assets. So quite frequently, a settlor will write up some notes for the trustees telling about the beneficiaries and explaining, you know, maybe this one is trying to go to college, and I really want the trustees to make sure that they select a good school and help pay for school expenses. Maybe there's another beneficiary who's working on setting up a business. So the grantor wants the trustees to help with funding and help watch the business grow and give business advice to the beneficiary so that they're successful in their business. So there's many ways that the private irrevocable trust can be used by the trustees to aid a beneficiary in experiencing the benefit of their interest. And the beneficiary can work with the trustees if they want that interest broken up and shared with perhaps siblings or maybe a spouse or a partner. We can go to the next slide. If it is real estate that the trust is caring for as an asset, this must be in writing. And in the United States, some states require if the trustees are going to actually pass over some of the property to the beneficiaries, they would require the trust to write a statement of a gift. And once something is given, once something is in writing, you can't give it again. So what that's saying is, if a grantor gives a piece of property into the trust for the benefit of their children, it's held in that trust for the children, and no one can interpret it as an asset of the children, because it is an asset in writing of the trust itself. Because you can't give it twice. And we could go to the next slide. Thank you so much, Tansen. These are so beautiful.
You're welcome.
So what's the restraint on alienation? So alienation is our ability to convey our interest. It's our ability to transfer our beneficial interest. In a lot of cases, this is called a spendthrift clause. And there are some, if you Google it, there are specific spendthrift trusts. The beneficiary is unable to transfer his equitable interest in the trust. And the reason for this is to protect someone who perhaps when the trust is formed, the grantor knows that one of the people that he wants as a beneficiary may have some creditor issues or may have a judgment against them that is a monetary judgment. And they want to do something to help care for that person without the assets being taken. So inside of Randall's beautiful private irrevocable trust, he has a clause in there that is very specific to the trustees that helps the trustees protect. And it's essentially a spendthrift clause, although right now it doesn't actually use the word spendthrift, but that's how it works. And another term for a spendthrift clause can be a discretionary clause. And basically what it's saying is that the trustee has discretion on how they're caring for the beneficiary. And because of this discretion, they cannot be forced to give the beneficiary a disbursement. And because of that, it is protected by law that a creditor cannot force a trust to sell assets to pay for a beneficiary. So that is the beauty of the protection of a spendthrift clause, or that the trust indenture is very well written to uphold the discretionary power of the trustee to care for the beneficiaries. This is very, very important, because once a beneficiary has received something from the trust, they have received a disbursement, the creditors can access those assets through the beneficiary. So it's not a perfect, oh, I'm going to be able to protect you your whole life long. If the beneficiary does have a judgment against them, once they receive a benefit, depending upon what state they're in or what country they're in, there are various laws that govern how creditors can access those monies or other assets. But for the most part, creditors cannot pierce through the trust and force the trustee to make payments. Now, based upon which states you're in or what countries you're in, you have to constantly be just checking out how are they interpreting various laws, because there are unusual circumstances where someone could sue the trust, and it's not that they could force you to sell an asset, but they could get a judgment where when you do make a disbursement to the beneficiary, you would be required to disperse a small amount to a creditor at the same time that you disperse to a beneficiary. So we have to understand there is a beautiful legal maxim that is working in regards to trust, and that it has to do with when a bestower of a gift, when that person gives a gift, they have a right to regulate its disposal. So that is why the spendthrift clauses and the discretionary trust, this is why the law protects this idea, because it is part of, I think that you would call it part of the law of equity. It makes sense that if I'm giving a gift, he who gives something, anything, can direct how the gift is to be used. That is a underlying principle of law that is respected by governments. So when we talk about the private irrevocable trust contract that Randall has written, it is not statutory because he's not a lawyer, but we review how statutory laws are being applied, because our trust is a legal entity, and in that way it can sue and it can be sued. So very specifically, the trust can, with a well-written trust indenture, the trust can help protect assets for the beneficiaries, and it can help protect the beneficiaries from creditors in this way. Could you do the next slide? So the beneficiary cannot sell or give away his right for future income or capital. His creditors are on alienation unless the spendthrift is no longer enforced. So in that sense, there are some trusts that are written where there may be a clause where the grantor says at a particular age or time, I want X amount of monies to be dispersed every year. So the trustee has to follow the guidelines of the trust indenture. And if the grantor has set up such that a beneficiary is required to receive a annual distribution or some sort of a monthly distribution, that would mean that the spendthrift clause is no longer being enforced, and the creditors would have access to the monies as it goes to the beneficiary at that time. But the beneficiary of the private irrevocable trust of Randall's, they can't take their certificate that shows their units of beneficial interest. They cannot sell that, and they can't give it away. They can't give away their future right to income. What they can do is they can talk to the trustees, and if they would like to transfer their interest for a really good reason, the trustees may agree with them, and they may reissue their certificates either to their children or their spouse, or split up their units of beneficial interest. But this is not something that a beneficiary can do. This is something that the beneficiary has to work with the trustee to do what they would like to do. So we say the beneficiary cannot sell or give away their rights to future income and capital. And the idea is that just because you have a right to future income and capital, that doesn't mean that a creditor can force you to experience that right now. So that's where the trust is respected as a legal entity, and per its contract, the creditors cannot force the trust that has a properly written trust indenture. They cannot force the beneficiary to give up their rights of future income or capital. So it's really wonderful. Next slide. Beneficiary must realize that once he has been paid, the payment is not protected and can be attacked by creditors. And this makes sense because in the world of contract law and equity law, we want things to be fair. So if a beneficiary does have a judgment against them, and it was fair, it went through court, whether you agree with it or not, it's been rendered as a judgment, then once that beneficiary receives monies from the trust, you can't say, oh, that was a trust asset, you can't have it. No, that's not how the law works. Once the beneficiary receives the monies from the trust, it is now no longer owned by the trust. It is now owned by the beneficiary. And that person has to follow whatever legal guidelines they are now under. And they may have to give portion of it to creditors, however their judgment was issued. So it's very important to understand that just because an asset was a trust asset, once monies are given to the beneficiary, it is no longer a trust asset. It is now held by the beneficiary. So now it can be accessed by creditors. Next slide. Who is allowed to invade a trust that does not have a spendthrift clause or a properly written discretionary clause? So if you don't have a very well written trust, you could have your trust have a judgment against it by suppliers who provide protection for the beneficiary's interest. one who furnishes necessities to beneficiary and they haven't been paid, a spouse or child who needs extra financial help, and also the federal or state.
Dominique, are you hearing? We don't seem to have a voice from you anymore. And your video is frozen. Okay, everyone, it looks like we may have temporarily lost Dominique. If you can hear us, Dominique, yep, the video disappeared. Maybe she has to reconnect. I'll just comment that while we're waiting for her to come back, that it was very, very interesting to me about this spendthrift clause. We've been hearing about it from Randall, and we never really focused on it much. But that's one of the many hundreds of ingenious features of the House of Freedom International Natural Law Trust is this clause, which the next slide, when we get to it, is going to show. It will show what the clause is. It's under units of beneficial interest section of the indenture. And by having that in there, it prevents the trust from being invaded by these parties listed here. So by saying a trust that does not have a spendthrift clause can be invaded by these parties shows the disadvantage of not having it, and therefore the advantage and the superior quality of our trust by having it in there. JB, you've got your hand up. I'll go ahead and bring you on and ask you, is there something that maybe I can help with, or do you want to wait until Dominique is back?
Tamsin, I can ask you, or you can transfer it to Dominique, but I had several questions. The beneficiary, what if the beneficiary transfers right away? Well, first of all, how does a creditor know that a trust exists? You're not registering it, and you don't even have to record it. So how does the trust know? The creditor know that you have one to go ahead and sue.
Oh,
So,
let's say it's a wealthy trust, and let's say that the beneficiary is expecting millions of dollars from it. I mean, you've heard of the trust children, you know,
right.
from wealthy families.
Uh-huh.
And usually it would be because the beneficiary is foolish enough to not keep it a secret, not keep it quiet, you know, that, oh, I've got, you know, this much money coming from, you know, XYZ trust, you know. So that's one of the ways, you know, is they just don't keep it quiet. And if it's a well-known family, creditors often have ways of getting behind the scenes and finding out what their private affairs are. But you've raised a good question, because if the family keeps it quiet and if the beneficiary is smart, that's correct. Nobody will find out about it because these trusts are private. That's one of its protections. So if you're a trust user and you're smart, you'll keep it quiet. And for example, that's why we don't recommend putting the word trust in the trust name. Supposing you have real estate in it and you post it on the county recorder and the name of your trust is ABC. You don't have to say ABC Trust. You can just say that real estate is owned by ABC and let the would-be attackers try to figure out, is this a foundation, or is this a corporation, or is this an LLC, or is it a 501(c)(3), whatever, you know. They don't know what it is, so they can't intelligently attack it if they don't even know what it is.
But can a creditor do a court thing? Because a judge can't pierce it, can they?
it
to
cannot
find
be
out who has the assets, you
it
know?
cannot be pierced, but it can have certain assets claimed if uh, the trust, the way it's written, allows for that. In other words, if the trust has promised certain things and those things don't manifest, then that provision in the trust could be enforced.
Oh, I see.
There is also
Yeah.
the story of the visitors to the Rockefeller house whose cat scratched them, the visitor, and they sued and they won. And they were awarded the cat because the cat was in a trust by itself. That's not to say that we should abuse that privilege and, allow visitors to our homes to be injured without compensation, but it does show the strength of the trust. They couldn't get anything else because the Rockefellers had all their different assets assigned to different trusts.
I see. Now, for discretionary, if the beneficiary loses that discretionary clause, if the assets go to the beneficiary, what if the beneficiary were to take that right away and create a trust his own or her own,
Correct.
and immediately save that loss of discretionary power and stick it into their protective entity? Can they now be protected with their own
Yes.
as trustee? Can they go from beneficiary to trustee, or how
Yes.
does that work?
Yes. You're thinking the same thing I was, that, if the beneficiary is smart, he or she would have his or her own trust and have that interest assigned to that trust, which would then create a whole separate island of protection. So
And
that any
can
personal liabilities of the individual would not be able to be satisfied by taking it from that trust because it's a separate legal entity.
Right. So when you first create your first trust A, can you create a trust A so that the trust B is for your beneficiary and he already has this trust B laid out, a separate trust already prepared for him so that
Yes.
he could be both beneficiary and own a trust to
Yes.
be a
Randall
future?
has said that that can be done, but he does not recommend that it have the same officers. It would need to have separate officers, separate
Oh,
trustees, and so on.
okay, okay. Like a splitting off the family, the children
Right.
leave the nest and create their own trust and protection as well. So
Right.
now the other thing is, what if you corrected your status as an American national, where these creditors don't have diddly squat over you or the entity? Is there any way of ensuring that? Because they can't sue because they're not in the system, period. Is that a little bit too advanced for anybody? Are we can't even begin to think that way, or,
Well, we
you
have
know,
all kinds of people acquiring these trusts. And what's great about the trust is that it works even for those who have not redocumented their status. But those who have filed documents on the public record to improve their status and make them less, vulnerable to suit are in a better position. We do
right,
have
because,
a
yeah,
text here from Dominique saying, "Hi there, power went out and internet. Wow," she says. But the fact that she did text me means she must have it back on. I'm waiting for her to reappear.
it could be your cell phone, right? That she texted you from.
Oh, here we go. Here she's back on. I'm just going to make co-host.
Well, thank you so much, Tansen.
You're welcome. Nice to have you on, and thank you for your good questions.
Thank you
Dominique.
for your who's creating these beautiful photos?
Oh,
I
I
can't
do.
believe that. How do you do that? They're awesome.
Oh, thank you. Thank you. Thank you. Okay, we have Dominique back. Welcome back, dear. What happened?
Thank you. Power went out, and I didn't think about it. My laptop's on, no problem, but the internet went too.
Wow.
Interesting
Unbelievable.
times. Interesting
Yeah.
times. I'm here in Santa Barbara, California, and I think we have way more people at home, and so I'm just assuming the power grid is a little different. It was very strange.
Yeah, that's rare for that area.
Yes.
Well, we had JB come on, and she was asking some good questions, and I just sort of discussed it with her. For example, the beneficiary having his or her own trust to receive the proceeds. That was one idea. And
Yeah, and
yeah,
I overheard you talking about how beautiful it is to use the anonymity of naming your trust something that can't be recognized, and don't include the word trust in your name. That's so beautiful.
yes. You ready for the next slide?
Sure.
I believe this one is the actual spendthrift clause.
Yes. Beneficial interest may not be encumbered, pledged, assigned, or hypothecated by a beneficiary. Ownership of a beneficial interest shall not entitle the holder to any legal title in or to the asset. And that's exactly how the law states this. Beneficiary can return his interest to the trust. The trustee can then reassign. So it's very specific in Randall's trust indenture as to how we are able to protect this beneficial interest. And because Randall's private irrevocable trust has these words in it, this, if you were challenged, this would be respected. Next slide. Time for questions.
Is your power back on?
It is.
So it was just the neighborhood power, huh?
I'm assuming so, but it did knock out good enough that everything had to do a reset.
Wow. Maybe, or maybe it's your high spiritual energy.
Very kind.
So those of you who have access to the chat, you can type your questions in there. Those of you on telephone, you can dial *9 on your phone. And those who have a smartphone or a computer access can click on the raise hand icon and raise your hand. And you can come on by audio.
You know, there's one other thing that I want to point out to people. If you're new to trust, what's very different with this private irrevocable trust is that we have units of beneficial interest, and you do not find units of beneficial interest in statutory trust. So there's not a whole lot of information out there regarding that. But because of these units of beneficial interest, this also helps to protect the beneficiaries.
I must say, Dominique, that you have greatly helped all of us to appreciate what we already have more than we did before.
It's beautiful. And I love it when people share with me other trust indentures, especially if they've found a trust indenture that is labeled asset protection, or that it was sold as a trust that as it's espousing that it has great asset protection. And I love reading those trusts and comparing them to Randall's trust indenture. And it's really beautiful how he has distilled. For example, in the United States, we talk about spendthrift clauses, but in England, they don't use spendthrift clauses. They use discretionary trust. So what they're saying is, does the trustee have discretionary power? That, in other words, it's up to the trustee's discretion as to what the beneficiary receives. So Randall has experience working with many different clients in many different countries, and he's been very it's just amazing how much knowledge he has accumulated to write a trust indenture that is based, when we say natural law, it's based on common sense about what's fair and how things should unfold. And always we have a trust to accumulate assets for the benefit of the beneficiaries. That is our purpose. So are we able to give ROE beneficiaries a one-time benefit and put others in their place? Oh, that's very interesting. So what I would say to that, that's a very interesting question. As a beneficiary of a trust, I am with working with Randall's trust myself, so I'm going to pretend that I'm a beneficiary. If it worked out such that my trust had a lot of assets, or the trust I'm a beneficiary of had a lot of assets, and they made a disbursement to me, and I went, wow, that's great, I don't need anything else, then I could talk to my trustee and I could say, gosh, thank you for the disbursement, distribution to me as a beneficiary. Thank you very much. Now I'm ready to assign my beneficial interest to someone else. So in that way, I would then be doing exactly what you're expressing. I would have received a one-time benefit, and then because I choose to, I can work with the trustee, and if the trustee agrees, they could take my beneficial interest and assign it to someone else. Does that answer your question for you? So you just, in my mind, I'm constantly thinking about, it's a matter of paperwork. It's a matter of paperwork, and it's a matter of understanding the definition of roles and the definition of terms. Can you illustrate how an LLC might interact with an irrevocable trust to manage the income of the LLC? That's an interesting question, and Tanzan, you might have a different take on this. From my point of view, I have my trust as a member, not a managing member, just a member of my LLC. And the reason why I don't want my trust to manage my LLC is it gives my trust more protection. So my trust as a member of the LLC is only receiving a distribution of profit from my LLC. That's their only participation. It's membership where when I have profits and I make a disbursement, I'll give some to myself and I'll give some to my trust.
What you could discuss is what Randall has said, that it would be helpful to remove most of the assets and income of the LLC from taxation by assigning it to the trust. But he said it would not be recommended to put 100% into the trust because that would raise eyebrows. But you know, he's like 95, 96, 97%, something like that. It would be the maximum. What do you think of that?
Yeah, and you have to work with, you know, good mentors and advisors. And if you have a specific question, you should shoot him off an email. But that's, so I don't really think of managing the trust, managing an LLC, but I rather think of the trust receiving receiving profit from the LLC. And like, for example, perhaps you have trademarks or copyrights. You could have your trust own the trademark and the copyright, and the trust could lease it to the LLC. And that would be another way for the trust to have a cash flow. But it would not be managing the LLC, slightly different.
Right.
Next question. How would the leadership consider the idea of setting up a certification course to train trustees following specific curriculum undertaken over a certain period that would provide trust owners and trustees a platform to have professional trustees train? So Peter, that's a very interesting question, and it's kind of what birthed our study together once a month. We've been reading the book, The Art of Passing the Buck. There really isn't, or at least I'm still looking for excellent training material to train in trust administration. It's quite a beautiful art because it's not just understanding a little bit about accounting, a little bit about investments and assets and protecting assets, but it's also the human qualities of interacting with beneficiaries and caring for beneficiaries. So there's a lot of qualities that we are hoping to find in our trustees based upon why we have set up our trusts and who our beneficiaries are. So that's very interesting. And I'm working through a couple of books, and Randall has given in our trust manual and in a number of places, Tonson has listed too, there are a number of excellent law books that if you're really interested in going deep in the subject, that's very excellent to read and understand, so that we understand the definition of terms, of various legal terms, and the best practices for keeping our trust safe from possible litigation and protecting assets and properly caring for beneficiaries. So that's a very beautiful idea, and it may be what's blossoming forth. Thank you for that.
There isn't a large enough international community of trust crafters and teachers to really organize something like certification as yet. What do you think, Dominique?
Well, it's kind of, how can I say this? The handle of the umbrella is in my hand in that Randall is mentoring us, but the umbrella itself is so huge and broad. I mean, we have to remember, Randall has, what, 30 years experience of reading case law and talking about things and watching how this worked and how that worked. So there's a lot of time spent not only just understanding legalese, but understanding people and understanding the best way to work with the whole umbrella of trust administration. So I don't know that I could foresee a certification per se, but it would be really good if we were able to gain knowledge of the definition of all the terms in our trust and our trust manual and our trust indenture, and that we understood some basic simple actions, like when you purchase a piece of property, what paperwork do you do? When you open a bank account, what paperwork do you do? When you do year-end financials, what paperwork do you do? So there, I could see us working together to gain better mastery over trust administration paperwork.
And so I would ask Peter, are you attending Dominique's monthly trust study group sessions?
It's a good place to start.
Yep.
So thank you for that, Peter. Next question. Let's see. I got an EIN for the trust to set up a bank account. And the IRS states they want a 1040. Do we have to file? And if not, if we do not file with the IRS, can the trust, as a member of an LLC, set up a loan to the LLC, and how is that done? So two complex questions in there. The first one in regards to the EIN. So when the IRS issues their letter, when you've obtained an EIN number for banking purposes only, and it says it when you're filling out the online application, it says for banking purposes only. The response on the letter is in regards to statutory trusts. And if you choose to, how you choose to work from there is based on how the decisions that you're making in regards to working with the IRS. How do you summarize that, Tonson?
Well said. Very well said. Yeah, and it's not 1040, it's the 1041. The EIN letter says you must file a form 1041 on that. And I just tell people that the only rights you have are the rights you know you have. So if you know you have the right to not file that because this is not under their category of a statutory trust, then you can exercise that right. And I'm here to tell you that all of us who have done that have had no problem for decades and decades and decades. Never once have we ever had a problem.
So the second question, how can a trust as a member of an LLC set up a loan for the LLC? So that's very interesting. I was just reading about when a trust loans money out. So whether it's loaning money out to a beneficiary or loaning money out to someone else or loaning money out to an LLC, the what's required is fiduciary responsibility. And what that means is it has to be of benefit to the beneficiaries. So how is that loan of benefit to the beneficiaries? Well, it has to have a reasonable amount of interest, and it has to have certain protections. It has to make sense. So the trustee cannot just willy-nilly, oh, I'm in charge of, a $500,000 bank account and I can loan money out to my brother George. It doesn't work that way. There is a great fiduciary responsibility that the trustees can only make loans that are of best interest so to get a cash flow going, that is in the trust interest, but the loan would have to be somehow or another secured, and the trustee would have to work out how that securing would be done and have a reasonable amount of interest. So the trustee would have to document what is the reasonable amount of interest that is happening at this time. And that's how you document your fiduciary responsibility. But yes, a trust could, even though the trust is the member of an LLC, yes, a trust could loan monies to the LLC, but it has to be done with fiduciary responsibility in mind. Do you have anything to add, Townsend?
It sounds good to me.
Excellent question.
Do you have access to the questions that we didn't get time to answer from last month?
I do. I was actually looking through them, and we went through some of them in the trust study group because I figured, well, we've been studying long enough. We should be able to answer these.
Right. So I was thinking when we get a few minutes between the questions and this webinar today, maybe we can touch on some of those, even if they're on different unrelated topics.
Absolutely. And what I did was I actually sorted them by beneficiary questions. So while we're waiting for other questions to come up, if it's okay, I will address the beneficiary questions from last month.
Perfect.
So last month there was a question asked, does an irrevocable trust have beneficiaries or exchange certificate holders? And if you study The Art of Passing the Buck, and specifically deeply read volume 1 and maybe even got into volume 2, you'll see that there are trust capital units and there are also units of beneficial interest. And Randall has done us all a great service by keeping our trusts simple in that we're using units of beneficial interest. So does an private irrevocable trust have beneficiaries or exchange certificate holders? We have beneficiaries. That's what Randall's trust has, beneficiaries. Let's see. Someone asked, how do you exercise your right not to file a 1041 with the IRS? That's something that, Tony, that you're going to have to work through and pull your information on. It's like everyone does their own independent study. So perhaps if you want, you could send an email to Randall and engage him on that. But
well,
yeah.
Actually what happens is Randall refers tax questions to me.
Oh, there you go, Judson.
He wants to protect himself,
Yeah, none of us are CPA or, licensed tax people. So we share with people how we're experiencing, our business life and so forth. But we recommend people work through getting their own advice on those topics.
Well, the answer is there's nothing to exercise. There is nothing to exercise. You're acting like, Tony, that there's some kind of big job you have to do or some sort of effort you have to make. It's actually the opposite. It's the absence of effort. It's just, like I said in my last comment, if the only rights you have are the rights you know you have. So maybe you don't know that you have the right to not file. If that is the case, then forgive me for saying so, but you would be acting in ignorance and foolishness. And that's how fools get entrapped and enslaved, is through their ignorance.
So
But
it's an excellent subject to do further research on.
the fact is that you have the right to not file. And the reason we've already given you is that it is not a trust that falls under their jurisdiction or their statutes. And if you know that, all you do is remain silent. Just keep your mouth shut. You don't
And don't
communicate with
volunteer.
them. You don't volunteer. You don't send them anything. You just avoid communication with them. You don't inform them that it exists.
Yeah.
So it's the absence of action that is actually the easiest path and the most successful one. And that
Yeah.
is the course that most of us have taken. And all of us that have taken that course, I've already told you, have not had a single problem. And that is the sum total of the answer. There's really nothing to exercise. You just have to be a knower. I'll say this, if you want more information, go on our website under legal help and click on revocation of election. And there you will get a really, really first class, state of the art, world's most advanced opportunity to raise your personal status and get the proper education authorized by Congress that has a 100% success rate.
Beautiful. Next question. Since the profession is evolving and growing and the need for it in the golden age, personally, I foresee a need to have some people with this understanding. We build a network, progress, let's see, the professional as we go. Oh, wow. That's really sweet, Peter. Thank you for your comment. And yes, that is what Tonson and Randall are attempting to do, is they're attempting to lift all of us in our knowledge of trust administration so we can help one another. Absolutely. We're building a network of people are becoming wise in the art of passing assets on, or caring for assets to care for the beneficiaries. Absolutely.
Yes. Well, we are a
but
community of people interested in making a better world, and some of the best types of activities out there for the use of the trust are humanitarian organizations, charities. Dominique works with the blind, those that help the disadvantaged, those who are cleaning up the environment, those who are helping disaster victims, releasing slaves from slavery, helping the poor and the hungry, in some way building a better world. And these trusts are ideal for that, so that they can pass on from generation to generation.
And Randall has written into his trust indenture that we, the trustees, can give to charity. So that's hugely important.
It's also important, Dominique, don't you think, to say that the trust has the right, the discretionary right, to give assets to parties who are not beneficiaries. In other words, you don't have to be a beneficiary to receive a gift from the trust.
Yes. And the trust has the ability to form another trust. So we always keep in mind what's best for beneficiaries, but it might be good. In my mind, this is what I'm going to be doing with my trust. As my assets grow, I want to break off my assets into smaller trusts and put one or two beneficiaries under that specific asset so they can learn to participate and help care for the asset that is producing a cash flow that they're benefiting from. So this trust indenture is really beautiful in, it's simple enough to understand, but it has the complexity for us to do very wonderful, clever things in the future.
Would you like to let JB come on and speak? She's raised her hand.
Sure.
Okay. If I can get it unmuted here.
I never mastered the raising of the hand.
Well, oh, it was very slow in responding. Finally, I got it unmuted. Okay, go
Hey,
ahead, JB.
hi, Tans, and hi, Dominic. I was asking questions before, but here's the thing. I am using some of those assets, quite a bit of those assets, and put myself in as beneficiary in order to not jeopardize the benefit of the beneficiary, their their growth, their interest, because once you devote those monies to projects, I'm confused as to how it benefits the beneficiary. So you might lose the funds, the projects may dwindle, it won't be an interest or a revenue seeking program necessarily. A lot of it will be humanitarian, like Tanzan made reference to. So how does that benefit the beneficiaries? That's why I put myself, Randall said, you can put yourself in as beneficiary also, as long as you're not totally the beneficiary. And that was simply because I wanted to cover myself with those projects.
So,
So how does that work?
sure. So what happens is the grantor will write a letter to the trustees explaining that this is what I want to happen with my trust. And for the way that I set up my trust, I actually put a couple of nonprofits as beneficiaries along with some of the people that I want to care for. So it's very clear that as the grantor, I have clearly expressed that I want certain humanitarian projects cared for as well as beneficiaries. And in that regard, hold on. In that regard, what the trustees would do is they would keep notes and they would have conversations. So the idea behind this trust is that this private irrevocable trust is that you're creating a family that has similar concerns. And so whatever it is of the impulse of the grantor to get this trust going and to gift into the trust assets that are caring for peoples onto the future, whatever their intention is, they document it for the trustees so that the trustees can uphold their wishes. So,
okay, but slow here a minute, because you obviously have strength in your grantor. My grantor lasted 2 minutes. And so my grantor is not wishing or suggesting anything to the trustee. So how does that work now? Because I have trustee and beneficiary. I'm a trustee and a beneficiary. There is no more grantor or settlor. So what do we do now?
In your particular situation, it's a little unique because I'm just going to suggest, I believe you had a nominee grantor, and that it is your trust, but you're choosing to hold the position as a trustee. Am I mistaken?
Yes, trustee and beneficiary, actually.
Okay.
Because
So,
of the projects that are going to be moving and of large magnitude. So I didn't know how to work that. So I wanted
right.
to protect the trust by being the beneficiary of those projects in case they failed or whatever. See, I'm only working on common sense, and I'm not sure that that's the best way to handle it. But anyway.
My understanding, just from having companies and business and so forth, it's all about documenting. So if you document in your trust minutes that this is the purpose of the trust and this is the purpose behind how the trustees are to fulfill the trust indenture, that is how you help protect your trust for any challenges in the future. But I believe there are a number of chapters in The Art of Passing the Buck that talks about being very choosy of who you make a beneficiary. Because if you know that someone who you want to care for, but you know that they're not going to be an easy person to work with, that might be a person who just gets gifts from the trust and not necessarily a beneficiary. You may decide only to have a beneficiary in your trust of just humanitarian projects, and other peoples that you want to help may just receive a gift from your trust. Can you see how there's flexibility in your trust instrument of how you choose to benefit others?
Absolutely, for benefiting that, thus the beneficiary. But in terms
No,
of
no,
asset, in
you're
terms of
allowed to give a gift. So you may choose not to have them listed as a beneficiary. You may
right, but
choose simply to give them a gift.
okay, but in terms of asset growth, or as long as it's a growth situation, I can't project that or promise that to this particular trust. Therefore, I do have other beneficiaries. I'm just also a beneficiary to keep those projects going, because I really, that's what those funds were intended for. So I
So we
do
want to
have.
keep this general because we have some people on the line who have a trust and some people don't. So
Oh, okay.
that's okay. Can you
Uh-huh.
restate your question in a more general way? And then we can address how Randall's indenture helps solve that problem.
Well, just that if you have multiple beneficiaries, in addition, like personal ones as opposed to other entities, how can you um, benefit the beneficiary if you
Yes.
really don't know how it's going to turn out with respect to um, the entity, or how I can't really phrase it. So if you
I think I have it.
if you
Let me,
mix beneficiaries, and those entities fail, those projects fail, how are you benefiting the other beneficiaries? So
so
I can't.
I can break this up a little bit. So number one, I believe you're asking about the responsibility of the trustee to making good choices as a fiduciary towards what happens with assets for the beneficiaries. And then the second is, how do you deal with beneficiaries who need to be served in different ways? So
Yeah,
some of
very
your
good.
beneficiaries may need, just once a year lump sum payment. Other beneficiaries may not need money, but they need emotional support. So there's a couple of ways that the trust indenture is written that gives you the ability to do this. Number one, it gives the ability to create many little trusts. And so for me, that's my intention, is I will be coming back to Randall and working with him to make sure that I have a strong layer of trust when I have accumulated enough assets, which usually they recommend over $500,000. You have a good amount of assets when you're ready to do this. And we come back and we work with Randall to create other smaller trusts that will specifically care for people. And then we can create other trusts that might have to do with projects. And if that other project, alas, doesn't work out well, it's in its own little trust all by itself. And so
Okay,
its
good.
effect, does that make sense? So
Yeah, that's great, because I mix right now. I'm mixing them up myself. Is
yeah,
basically equal to the entities that I'm going to be setting up, and of course my family, my children, those kinds of other beneficiaries. But I mentioned to Tanzan before you came on about having those beneficiaries have their own trust to
yes,
avoid
that
that
problem.
the clause that you lose once you gain the asset. So if you create your own trust and slide that asset right into that trust for that beneficiary, where they're both the trustee now and the beneficiary, then they're now protected with that clause. They're no longer unsafe. You know what I
Yeah.
mean? They're secure if you create a trust for them, so they can now use that money. You're transferring it from one trust, the mother trust that you created. You're transferring their asset so they can use it. They
Yes.
should put it into their trust. As a
Yes.
trustee, now they can use it. They can give themselves that salary that was theirs as a beneficiary, and still now be protected under that clause, so that they cannot be sued. Do you know what I mean? And
So,
that, I don't know if
so
that's
yeah,
possible.
so to summarize it, yes, Randall's indenture is written in such a way that the trustees can create situations, if necessary, create little mini trusts that will help serve the interests of various beneficiaries. You are correct. We have
Oh,
the
good.
ability to do that. Yeah.
Any way you can dodge the bullet there. So, do you know what I mean?
You would work with him on it because he would help you know who are the people who should be in which position, and make sure that you have an adverse trustee to make sure that the trust is not an alter ego. So that's
Right.
part of why we continue to work with Randall on creating layers and so forth.
And could a nominee grantor be also a nominee trustee? Oh, no, you can't be a nominee trustee. No such thing.
I mean, Randall didn't have a negative comment in regards to that, but in our study group, I expressed my personal feeling that
Right.
you can divvy up, with the trustees, maybe one person's in charge of this and another person's in charge of that, but you're sharing a co-trustee unless the person is a successor trustee. And even as a successor trustee, I'm asking for anyone who I'm holding as successor trustee, hey, include me in a meeting, once or twice a year, so I know what's going on, so that if I had to take the reins, I would be able to care for the beneficiaries.
Oh, okay. And one more point about recording the trust. I don't believe you have to record it or register it.
I don't believe that that if you do that, then you're putting yourself under a statutory body by doing that. So no.
Why? If you record it, I mean, I'm saying you don't have to record it.
Correct.
You definitely don't register it.
Correct. Do not.
So
It's a private contract.
So nobody knows you even have it.
Correct. It's a private contract.
Good. I thought you had to record it, but not register it. Definitely not register, but you should record it. And I'm glad you don't have to record it either. Good.
It's a private contract. It's private.
Right. Yes. And so I don't want anything public. So that would be great. But I thought you lose some sort of irrevocable status if you don't at least do one, or
think about the definition of the terms. Irrevocable is in regards to when the grantor exchanges assets into the trust, he cannot take it back. That's what irrevocable is.
Right.
So nobody bestows that on you. That is in your contract that you've written with your trustees. You're the one who's saying irrevocable.
Okay, because I can't figure out for the life of me then how anyone can find out what you own, and that's all I'm.
Gotcha.
That's what I'm. And Randall's point was, if you don't say anything, they're not going to know anything. They certainly can't sue you as creditor, as a creditor. So anyway, thank you so much.
Absolutely.
That's one of the main reasons we don't know of any of our clients who ever have had their trust sued.
Yes.
It's one of the main reasons is that it's very quiet, it's very private, it's kept in the background. The only place where anything might be recorded is the ownership of real estate on a county recorder. But even that, you could just give the name of the trust without the word trust in it. And so the public doesn't know what kind of entity it is. It just knows that that name owns that property, and that's it. They
But
don't
they
know
also
anything
can
about who
find
the
out.
officers are. They don't know anything about the beneficiaries. They don't know any, it's not publicly posted, what all the internal workings of the trust are.
They can find out through your bank though. If
No.
a judge orders you to list
Now you're
your
getting,
banks and
yeah,
stuff.
further on. So let's hold it
Okay.
for that, because that's a
No,
more,
let's hope.
yeah,
Yeah, let's table that. Okay, thank you guys
Thank you,
so much.
JD.
You're
absolutely.
welcome. Okay.
Another question that was asked is, can the trust purchase an asset, for example, silver and gold? And if yes, how? So, Tanzan,
Well,
if you,
there's a
do you want to
question
take
you
it?
missed just before that. Did you see the
Oh,
one
beg your
before?
pardon. Well, would you like to answer that one, and then we'll catch
Uh,
the one before?
Amarval said, confusing that a trust has the right to give benefits to people, organizations who are not named as beneficiaries in the trust. How could this be in harmony with the main mission of the trust and the intentions of the grantor settler? Well, one way would be if you are a trustee and you are one of the beneficiaries, then what was intended to be distributed to yourself at a later time, you could gift away without taking away from the percentages that the other beneficiaries have. Dominique, any other comments?
Absolutely. And from the way that I understand is best practice of working with your trust is that I'm assuming that it's either family members or adopted family, as in close friends and so forth, that you would be making a beneficiary. And you would be having a conversation with them and say, hey, I've created this. I want you to participate as a beneficiary. Here's my ideas about how we're going to help our planet, help our community, help our family be better, and support causes that we believe in. So it's really about having an agreement in the family that you have created with your private irrevocable trust.
Okay.
So next question, can trust purchase assets of silver and gold? Do you want to explain how that's done, Thompson?
It's such a simple answer that it's just the same as any other transaction that you would
It's a
do in your
bank
personal
account.
name. Yeah,
Yeah.
I mean, so first of all, you presumably have been successful in endowing the trust bank account with some money. And once the money is in the trust bank account, just make the purchase of the asset from the trust bank account, and then record it in the minutes of your trust that the trust on this day purchased this much of gold or silver or whatever, and that the trust now owns, the title of ownership is now recorded in the minutes of the trust.
Perfect.
And you as a custodian of the trust can still keep, physical custody of the assets if they're physical assets. But the title of ownership is in the trust via that mechanism.
Yes.
I would also say that if you have any further detailed questions about exactly how to do that, ask either Randall or Dominique privately when you wish to make that transaction with your trust.
Yes. Excellent question. Next one, grantor exchanges assets into the trust. What is the grantor receiving in exchange for these assets?
Good question.
Excellent, excellent, excellent. So most of the time, the grantor is receiving at least a unit of beneficial interest, but the grantor may decide to assign those units of beneficial interest to a beneficiary. So the exchange of the assets is in regards to units of beneficial interest.
They're kind of like shares of stock.
Yeah. And Randall literally has certificates, and they very specifically say on them that they cannot be sold or transferred. They can be turned into the trustees and reissued.
Right. And they also cannot be taxed because there's no public exchange for them and there's no publicly available mechanism for determining their monetary value.
Correct. The next question, if you're required to have an EIN for the trust, isn't that the same as registering? So my understanding is because of 9/11, we have, as a society, we have agreed that our banking institutions need to monitor money flow, that's for the protection of our society. So when a trust obtains the EIN, when you work with Randall, he helps you, he has a beautiful document that helps you fill out the information correctly on the online system, such that you are asking for it for banking purposes only. So in that way, I've not experienced it as a registering.
Registration would mean you have disclosed who all the officers are. You have disclosed what its assets are. You have disclosed what its purpose is.
Yes.
You've disclosed a lot of information. None of that gets registered with the IRS. All they have is the responsible party and the responsible party's social security number, and that's it. And guess what? Anybody can be the responsible party.
Yes.
Randall was making a joke in one of the webinars once. He said, you could go out on the street and say to someone, hey, you want to make $50?
And they could be, yeah.
They could be the responsible party, you know?
Yes, yes.
So
the purpose is that.
And the IRS knows that it's an irrevocable trust. That's it.
Yeah.
They don't know. You haven't told them it's common law. You haven't told them it's sovereign. You haven't told them it's natural law. They don't ask, and they don't, and you don't tell. So don't ask, don't tell. The fact that they don't have any information about it means that's not a registration. That's not a registration. All that is a number assigned to a name. That's it.
And it's simply so that as a society, we can watch for money laundering, and we can watch to make sure that our society is participating in legal and lawful contracting with each other.
So again, we are here to tell you that we've been doing this. I've been using these since 1993. Randall's been using them since the 1980s. Dominique has been more recent, but she's been intensive.
2017.
Very intensive, and coming from a very rich knowledge background of statutory law, and then what, about 2 years now, 3 years using natural law trusts?
Yes.
Intensively, and I mean studying it every day and consulting in it. And none of us have had any problem with the EIN.
No. Yeah. So the whole point is, if you're engaged in legal activities, this is a wonderful trust for you. If you have something nefarious, do not purchase this trust. It will not work.
Exactly. Well said. Thank you. I think that's another reason we've been very fortunate in having no problems with the trust, is that we've attracted such a wonderful, really wonderful community of people who are peacemakers.
Yes. Yes, yes, yes. Let's see. More questions. A lot of people have questions about banking and so forth. So in regards to beneficiaries, I just wanted to say just real quickly, if you're not involved in this trust yet, Randall has a beautiful document that he put together to help you understand how the trustee opens the bank account for the trust, and that the trustee does not reveal who the beneficiaries are. That is not something that any bank needs to know. So as a trustee, if you are working on getting your trust account open and you're sitting with a banking personnel who says, oh, well, I need to see your entire trust, what they're really asking for is the trust indenture, which is perfectly fine. That is a beautifully well-written contract that tells them exactly what they need to know, that you have the ability to open this account. But you do not give your schedules that show your assets and your beneficiaries. That is, you do not share that. And if a bank says, oh, well, I have to know who your beneficiaries are, go to another bank.
Right. And I also point out to them clause 7 in the trust certification minute, which says that the bank is not responsible to enforce the provisions of the trust.
Correct.
They are
They're not responsible for interpreting.
right. So that way they're off the hook. They don't have to know.
Yes.
Because, most people are like little children and they look to the banks as big daddy and big mommy to take care of them and protect them. That's how the statutory system works. They're not used to dealing with sovereigns and people who think independently and, are mature enough to act on their own. But that's what we are in this community.
Yes. And if you want to understand the various hats that we wear, a hat is a settler, a hat is a trustee, a hat is a beneficiary. And then there's also an additional 2 positions. You could have someone who's like an executive manager, and you could have a protector. So if you're interested in those hats, there is a previous seminar. It's on Brilliance and Commerce's replay list where Randall talks about wearing the 3 hats. And it's really excellent. So you should watch that replay.
Yeah, he actually brought some hats with him on the webinar.
Let's see. There was an interesting question asked in February. How do I set up for 2nd level beneficiaries, 3rd level beneficiaries with a minute that sets the time frame of when these levels kick in? And Randall responded in writing to me, yes, it would be an appointment document and a trust minute. So in other words, a beneficiary can express to the trustee, and they can document it in a trust minute that, hey, this is how I want my units of beneficial interest to flow. When I'm not here, I would like it then to go to my child or my spouse. And then if they're not here, I want it to go to their child or spouse. And you can set that up in the minutes. And the other thing is, in Randall's trust indenture, it clearly says that the beneficiary, if a beneficiary passes away, the heirs of that beneficiary, they cannot force the trust to sell assets. They can't force a disbursement. What they can do is they can say, hey, I'm the heir of this beneficiary and I would like to receive this person's units of beneficial interest. And if the trustees know that that's in the best interest, they will reissue the units of beneficial interest. And that's clearly detailed out. So there's so much about running our trust that is literally in our trust indenture and in the manual that Randall has given us. Let's see. Another beautiful question. How do you see beneficiaries contributing to the trust? Are they not just receivers of benefit? I do not understand how they can, I do understand that they could decline a benefit or reassign them. So this is how you get them to participate. You could educate them on trust administration, and they could choose to, if you find them worthy, to become a co-trustee with you to help care for other beneficiaries down the line. So the idea behind trust administration is not just that we ourselves become excellent trustees, but if we can nurture any one of our beneficiaries to take our place, that would be of fantastic benefit to the trust to move from one generation to the next. So we are looking for beneficiaries that we can coach and counsel in life experiences, in business, and this takes time. It may be a decade or 2 before a beneficiary has had enough life experiences and enough business experience that you would consider them for a co-trustee position. But that would be outstanding. Our first asset is always our human capital. So if we are caring for the experiences, the life experiences that all of us are having within our family of our trust, and we nurture our beneficiaries to, perhaps one or two of them to become trustees in turn, whether it's our trust or whether it's their own trust in the future, we are creating a mindset of caring for our families and caring for our planet. So that's how we can get beneficiaries involved. But it's a case-by-case basis.
Very good.
Excellent question. Let's see. So there was another question about beneficiaries perhaps having assets and wanting to put assets into a trust. And Randall wrote a note saying, it might be better to think of it that if a beneficiary has an asset that they want to put in a trust, that they would create their own trust. So you kind of have to do proper accounting. That's the huge part of trust administration, is recognizing not only the monies coming in, whether the monies are income or whether they're corpus, but we also need to keep good trust minutes of why we're choosing to do the different things that we're choosing. And when we exchange assets into the trust, we're watching the flow of things so that everything is clear and transparent and auditable. So it makes more sense for a beneficiary to, if they have assets, to create their own trust.
It also illustrates the point that another trust can be a beneficiary.
Yes. Let's see. So someone asked a very specific question last month. Is it possible to be, and I think this speaks to Jan's question as well, is it possible to be the grantor and they call this managing trustee, so that's like the main person doing all the trust paperwork with other trustees? And what Randall was suggesting is, yes, you can be the grantor and you can be the first appointed trustee. You should have a co-trustee who's not related to you, but you should not be a beneficiary. So it is okay to wear 2 hats, but not 3 hats. Let's see, a continuation on a question. We seem to be in a bit of a catch-22 right now. There are many people, both young and old, who are on the edge of financial fragility. So very fragile. It's difficult to see this transition, including the grantor, to a state of financial stability that ensures that the trust continues to go on. So all I can say to speak to this is that by having the trust and getting this trust going, you now have a vehicle that's ready to drive. And there are so many different things that is really good to learn about trust administration that in some ways, for me personally, I'm kind of relieved that I don't have a huge amount of assets to be concerned about, because I'm not pressed to make those financial decisions and fiduciary responsibility that might be more stressful if I have to do it in a rush. So I actually have time to absorb the knowledge that I want to have when I do have those assets. So I feel in a really strong position of having my trust instrument now and understanding how it works so that I'm ready for the assets that I know are coming in the future. I hope that helps. But you're right. I mean, it is a bit of a catch-22 that there are many people who want to learn about operating a trust and having a trust, and yet they lack the current flow of liquidity of funds to do so. So all I can say is change is a wonderful thing, and I'm foreseeing beautiful things for our future. These are all wonderful questions.
Wonderful answers.
So part of the main way that the trustees keeps that really good relationship with the beneficiaries is documenting and making trust minutes and documenting why it is that they're making the decisions that they're making. So the trust minutes are trust minutes save trust is what the mantra is. So let's see. I think we've done pretty good.
Okay, well, thank you. Yeah, I think we can move on. This has been a little bit shorter, not such a marathon as last time. So next month, we will have our next webinar on April 15th. And any questions you have after the webinar, be sure to email them in. You can either click on Contact Us on the BIC website and send them that way, and they'll get to Dominique or Randall or myself. And then, or save them, write them down and save them for next month, and we'll entertain them then. And be sure, if you have a natural law trust, to attend Dominique's April 8th Trust Study Group session.
Perfect. And we are studying The Art of Passing the Buck, Volume 1. So if you do not have that book yet, please get a copy of it. And we're having a lot of fun with it. Thank you so much.
House-of-freedom-trust.com for those who don't have a link. Sign up to the newsletter.
Thank you so much, Tanzan.
Well, you've really filled the day for us, Dominic. I want to thank you. Everyone, we had expected our dear friend Randall to possibly join us today, but he had to go to a doctor's appointment, and then he had lack of Wi-Fi, and he said he had a computer problem, and he just had a lot of strikes against him to make it on the conference today. But fortunately, he's been in touch abundantly with Dominique, and they've had a lot of discussions about preparing for today. So she was ready, and thank you again.
My pleasure, my honor. I just so appreciate what Randall has created. It's just so beautiful.
Oh, looks like we do have one last question. Liaz, L-I-A-Z. You're unmuted, but you have a question quickly before we close?
Sorry.
You're on the air, if you can speak up.
Oh, actually, I'm sorry. I'm just kind of new and I just got on finally. So no, at this time, I don't have a question. Thank you very much.
Well, nice to speak with you anyway, and have a wonderful day.
Great. Thank you.
Okay.
Blessings and be well to everyone.
Fly high, dive deep, and be well.
Yes.
Okay.
Thank you, Tanzan.
Thank you. Take care.